Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Kyle Ubel, a Minnesota construction lien law expert. Today's webinar topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the wonderful and fabulous Kyle Ubel.
Thank you, Jesse. As Jesse mentioned, I'm an attorney in Minneapolis, Minnesota at Frederickson and Byron, and I'm here to talk to you today about what happens after you record your lien on a project and how you go about getting paid. I am going to start with just a 3-bullet point primer for everybody on lien recording procedures, just to get everybody caught up to speed on that if you haven't heard about this before. You go about recording a mechanics lien statement in Minnesota by filing the lien statement with the county recorder. You have to do so within 120 days of your last contribution to the improvement. You serve the mechanics lien statement on the owner by personal delivery or certified mail, file it with the county recorder, and all of the procedural requirements for recording a lien are strictly construed in Minnesota, or your lien rights are lost. So it's very important that you carefully follow the procedural requirements in the statute. And then another trap for the unwary is do not overstate your lien amount. If anything, you want to be a little bit on the underside, because if you overstate your lien amount, it can actually create a defense against the lien. And if the court finds that the amount that you stated was due in the lien statement is too much, you can actually, that can be a defense to your lien. It can be a reason for the court to disregard the lien. The other trap for the unwary is the 120-day deadline. So what will often happen is, a contractor will say, oh, I want to get a lien recorded, and it's been 125 days. If there are legitimate items of work that you can go back and do, you can go do more work on the project to extend that 120-day period. But what you can't go do, there's a body of case law that has developed that's called the screen door doctrine, and a contractor will go back and tighten the hinges with a screwdriver on the screen door hinges and say, okay, now I did more work and now I have a renewed period to do the lien right. The lien recording, and the court said, no, it's the screen door doctrine. If you're going back and tinkering with the screen door, that's not contribution. But if you're sending new material or you're performing substantive work on the project, you can reset the 120-day period. That's lien recording in a very fast, abridged nutshell. Then we get on to the topic of the day, which is what happens after you file a lien. Often what happens is that grabs the attention of the project owner or their lender, if they have a lender, and they will pay you. They'll call you up and they'll negotiate payment. If that doesn't happen, there's another trap for the unwary, another deadline that you have to be aware of, or you definitively and permanently lose your lien right. You have to file the foreclosure lawsuit, the lawsuit foreclosing the lien, within 1 year of your last day of contribution on the project. So you have 120 days to record, and you have a year to file. So that gives you 120 days, that's 4 months. You have approximately 8 months, depending on how the calendar falls, give or take a day. You have eight months from when you record to when you have to file. I would suggest that most everyone listening today probably does not have in-house counsel that does litigation for them. So you're going to need a lawyer. If you get to the point where you say, I need to file a foreclosure lawsuit to foreclose the lien, you're going to need to get a lawyer. And I would suggest that you retain counsel well in advance of that 1-year deadline. If you call your lawyer of choice a few days before that 1-year deadline to get a lawsuit filed, they may well say, I don't have time to help you, and you're going to be scrambling to find somebody suitable who's going to have the time and the capacity to do. So make sure you're calendaring that deadline. Make sure you put something on the calendar a month before to start talking to a lawyer. Now you get your lawyer, you've decided to move forward with the foreclosure. What does that look like? First thing that the lawyer is going to do is file and serve a complaint, a foreclosure complaint. That formally starts the lawsuit process. all of the junior lien holders, the junior creditors on the property, will be named as additional defendants. More on that in a minute. Once the complaint is filed, the parties will take discovery. They will send each other written requests for documents and information. There may be depositions where folks sit down and they're interviewed under oath, much like you'd be questioned in court. If you're on the stand, you sit down in a conference room at a lawyer's office and people ask questions about the project and whatever defense people think they have for not paying. That all happens under oath, and that's testimony in the case. And once discovery is done, the lawyers may conclude that depending on what information was developed in the discovery process, excuse me, that it may be appropriate to move for what's called move for summary judgment, meaning you'd go to the judge and say, we don't need a trial in this case based on what we've learned in the discovery process. Judge, you can decide this case right now in our favor, and we don't need to have a trial. If the judge says, no, I think we need to have a trial, then the last step in the litigation process before the foreclosure sale would be to have a trial. And assuming you win as the contractor or the lien holder, you win, you'll get a judgment of foreclosure from the court. Then the foreclosure sale process starts. You take that judgment from the court, which is the document saying you won and you're entitled to foreclose, and you deliver a copy, a certified copy of the judgment to the sheriff's office in Minnesota, in the county where the property is located. At the same time, your lawyer's office will publish notice of the foreclosure sale. They'll schedule the foreclosure sale date with the sheriff's office, and then they publish for a period of 6 weeks an advertisement, basically, in eligible publications, newspapers, legal publication services, things like this, for a period of 6 weeks, informing the public of the sale. And the notice of sale is served on the project owner, the debtor. Then the day of the foreclosure sale comes. What very often happens is that the only person that shows up at the sheriff's sale is you, the person who's owed money. And the bid amount that you bid in at the sale is the amount that you're owed, plus interest and fees. So if you say you're owed $100,000 and your lawyer has spent $10,000 and you're owed interest of another $1,000 and you're entitled to fees of $1,000, you're going to bid in $112,000, 100 plus 10 plus 1 plus 1. These are just round numbers as an example. And if there's nobody else at the sale, you will have won the auction. You've bid in the amount you're owed, so you don't owe any cash because you're effectively using the debt you're owed to pay for the property, and you have won the auction. You have won the sheriff's sale auction for $112,000. The sheriff's office will then prepare a report of sale, filling out, it's a pre-made form. The sheriff's office will fill out the report of sale describing what happened, who bought the property at the sale and for what amount of money. And you take that sheriff's report of sale and you go back to the court with your lawyer and you file a motion to confirm the sale. Basically you're handing the report of sale to the judge and saying, Judge, this is what happened at the auction, and we want you to confirm it. Couple things. If more than one person shows up at the sheriff's sale, there could be competitive bidding. And if the project is worth enough, if it's $1 million project and only $112,000 is owed on it, somebody might say to themselves, well, gosh, I'll pay $113,000 to get $1 million project, or I'll pay $200,000. And let's just assume that people bid against each other for a while and you get to $250,000. That person doesn't have their debt to bid in on, so they actually have to come with cash, a certified check. And they have to pay $250,000 to the sheriff's office. You will get $112,000 of the $250,000, and the project owner will get the balance. The project owner will get the balance. Okay? That's how the sale process works. If you go to the motion to confirm sale and for some reason the amount bid in was less than the amount you're owed, then you would say in connection with the motion to confirm sale, Judge, we need a deficiency judgment, which is a money judgment to go after the project owner for the difference. So if only $100,000 is bid at the sale and you're owed 112, in connection with the motion to confirm sale, the judge would issue a deficiency judgment in your favor to go to collect money in the amount of that additional $12,000 from the project owner. That's a deficiency judgment. But it's not done yet. It's not done yet. We've got the redemption process. So recall the example where the property's worth $1 million and someone pays $200,000 for the property at the sale. There's $800,000 of equity, assuming there's no other debt recorded against the property in my example. There's $800,000 of equity. Most owners are not going to want to let $800,000 of equity go away, right? So they have a 6-month period of time to do what's called redeem the property. They have to go figure out with a banker or a lender or a family or friend who has the cash, how am I going to come up with $200,000 to get the property back so I can keep my $800,000 of equity? And if they can do that within 6 months, they pay $200,000 back to the person who was the winning bidder at the foreclosure sale. They fill out and record a certificate of redemption. And now the person who paid in $200,000 at the sale, they get their $200,000 back plus interest. They're out. They don't own the property. They lost out, and now the owner retains the property. You got paid out of the auction. Winning bidder got paid back plus interest. Owner keeps the property. That's example number 1 on redemption. If the owner does not redeem at the end of 6 months, then each of the junior lien holders on the project have successive 7-day periods in order of priority to redeem the property. Same process. They might say to themselves, hey, we'd like the opportunity to use this situation to get paid ourselves, and we're owed 50. So we're going to pay off that 200. We're going to bid in our 50 of debt, and now we've got a property worth $1 million. And that, that can work out for people. And then the next junior lien holder would have another 7-day period to do it, and so on and so forth. So if there's 6 junior lien holders, they'd all go in order of priority. They'd all get a successive 7-day period. What I'll tell you is that in practice, in my years of doing this, if there's significant material equity in the property, the owner always redeems. They're never going to let that equity go away. They're going to find some banking deal somewhere to get the job done within that 6-month period of time so that they don't lose their equity in the property. Once the redemption period is expired, then the process is final, and whoever is standing at the end of that process holding title, not redeemed, they are the owner of the property. That's how you get paid through the mortgage, the lien foreclosure process in Minnesota. Are there any questions about that?
Well, first of all, Kyle, thanks so much. You really are wonderful. You were able to break down a bunch of really good topics for us. So thank you so much. There is a question that has come through. It says, do I have to be licensed in Minnesota to have lien rights?
Yes, you do. And perfect. Along with licensing, to have a license in Minnesota, you have to be insured. So you have to be licensed and insured in Minnesota to have lien rights.
Okay, wonderful. Another question that was posed is, are you able to amend a lien to adjust the lien amount if you are still within your time frame before that deadline?
Yes, you can file amended lien notices of lien, yes.
Okay, and then I think there's one more question that was posed. It says, does an architect or an engineer have lien rights?
Yes, to both.
Okay, wonderful. Those are easy, pretty simple questions for you to answer. So thanks so much. I do think that that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any other questions for you. Can you go to the next slide for us, please, Kyle? All right, so here are some of SunRay's resources to help you stay organized and know your deadlines, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember each state is unique in its lien laws and deadlines. So please take a look on our site. It will help you with what type of documents are required and what those deadlines are associated with your roles on the job. And then the next slide, please. All right, if you don't mind, give us a quick review on Google. We really do appreciate any feedback you're able to provide to us. So again, scan that QR code. It really only takes about a minute of your time. And then the last slide, if you don't mind. And with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Kyle, again, you really are wonderful. So thank you so much for your time and all of your content and your information that you were able to provide. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.
Take
Bye.
care. Bye-bye.